Hi Shraddha, welcome to NEXWEB podcast.
Hi, Shrishti. Thank you so much for having me today.
Shraddha, can you share your background? Why did you choose registered migration agent profession in Australia?
Well, I wanted to start a business of my own, and I love talking to people. I love giving advices and doing work of a counselor. And so I was researching occupations, and I thought being a migration agent would be a very good profession where I can deliver what I want to the public. And I thought I'll be an excellent source as well because I always value truth. I value doing right things. So, and I thought with the profession itself, it's a good, reputable profession if you take it that way. So I thought I will flourish in this profession and do a goodwill at the same time.
How long you have been working as a registered migration agent?
It's been more than 3 years. When I first got my registration, I was very fortunate enough to be working with a very reputable another migration lawyer. His name is George Lombard. I worked for him for almost a year, and I got to learn a lot from different visa subclasses. Very hard cases and all. So even though it's only been 3 years, I feel like I learned a lot, especially in that first year of becoming a migration agent.
Shraddha, nowadays I can see applicants so much confused either to study in regional or city or which course to study, and can they migrate to Australia in global talent visa, business visa, contributory parent visa, non-contributory parent visa, and can they get sponsors, permanent residency from overseas as a registered migration agent? What you suggest?
Well, for first of all, for any immigrants who are already, whether they're onshore or offshore, general skill migration or employer sponsorship, these are the main two visa categories where they can try their permanent pathway to Australia if they don't want to come to Australia on a student visa. And with the employer sponsorship, they need a employer to sponsor them. So there goes the main problem. But if you can find an employer who is willing to sponsor you, and the applicant themselves meet all the criteria, amongst the criteria, the main thing is they need to have certain years of experience. So if the employer is there, if you meet the criteria, then employer sponsorship is the best because your PR is guaranteed that way. Besides that, general skill migration, which is what normally everyone is after, which is subclass 189, 190, 491, the state sponsorship and the regional one. With that one, it's more on your own merit. So, which occupation you're in, whether you're in a very high demand occupation or not, or whether you are located in a place where your demand is more, right? So, things like that governs the general skill migration. Therefore, general skill migration is also a good pathway for both onshore and offshore. For example, I've got many engineers and chefs as well who's got direct permanent residency from offshore. So that's another pathway. Now, talking about global talent visa, that visa was particularly created mainly during COVID because the general skill migration program was shut down during COVID. And, being a country made of immigrants, Australia could not have migrants coming in because of the lockdown. Therefore, they created this global talent visa subclass. It was there at the back, as a background, but not as active as it was during the COVID time, and the quota was quite high. They were, giving invitations to all the talented people. But as the COVID, subsided, as the lockdowns opened, the quota also got reduced from 15,000 to 5,000. And the period of time where the decision was being made was previously within a month to 3 months, maximum 6 months. Now it's taking even up to 2 years. So I wouldn't encourage people going down the global talent unless you are highly talented, unless you are a very high income earner kind of person. For others, I would say general skill migration is the best pathway for now. And the parent visa and the family visa is a different category. So if you want to talk about that, I'm happy to talk about that as well.
Yeah, I really want to know about the parent visa because Australia is the country of immigrants, and their children really want to sit with their parents, right? And they want to bring their parents in Australia. Like, what are the process to bring parents in Australia?
there are, I'd say, 6 to 7 visa subclasses if someone wants to bring a parent to Australia. So first of all, you have to the children has to be either permanent resident or a citizen. Okay, and there's another thing called balance of family test. So if you meet the balance of family test, you can sponsor your parent for permanent residency. How that balance of family test works is that 50% or more of your siblings or of the applicant's kids must be Australian citizen or permanent resident. And so, for example, if there are 4 kids, if 2 are Australian permanent resident, you meet the 50%, right? But let's suppose there are 3 kids, only one is Australian citizen. You'd think that they don't meet the balance of family test, but they actually can meet the balance of family test if the remaining 2 are citizen of 2 different countries. So the balance of family test, how it works is you need to have 50% or more in Australia than in any other country. So let's say, for example, 3 kids, one is in Australia, one in India, one in America, right? Then they meet the balance of family test. So that's the first step. Second step is for the parent, there's 2 categories of visa subclasses mainly. One is contributory and one is non-contributory. Contributory is very expensive, but the good thing about contributory is the whole figure, which is 47,000, you can say 48,000, $48,000 for one parent or $94,000 for 2 parents. The whole amount is payable towards the end. Right now, the waiting period can be anywhere up to 12 years. So the whole amount is payable at the end. At the start, when you want to put them in the queue, you only pay about $6,000 for the 2 parents. So don't think it's $97,000, $94,000 straight away. It's only $6,000 now, and you put them in the queue, and it can take up to 12 years, but you only pay the remaining, 80 something thousand dollars after the 12 years time. So at least, within that time frame, if you're thinking of selling your property and stuff like that, or if there are few kids and they want to save up, at least you can do that. That way your parent will get permanent residency in around, between 8 to 12 years. And the other one is non-contributory. Now, non-contributory is really, really good if one of your parent is 66 years and 6 months. Because with the non-contributory, the waiting period right now is 29 years. Trust me, your parent will never get the PR. It's just going to go up and up and up. But the good thing about about that non-contributory is if the parent is 66 years and 6 months, they can get bridging visa to live and stay in Australia. They can travel in and out, but at least they get to stay here for life, forever, on that bridging visa. And it's only going to cost you around that $6,000. That's why, I'd say if financials are your problem, then go for non-contributory if one of your parent is off that pension age, which is, again, 66 years and 6 months. Now, let's say you don't meet the balance of family test and you still want your parent, but you can't have your parent here permanently. You can have them in Australia temporarily up to 3 years or up to 5 years. And that is the sponsored parent visa. But that's not a very cheap visa subclass. 6 years would cost you around $6,000 for one parent. Sorry, 3 years. 3 years would cost you $6,000 for one parent. And 5 years would cost you around $11,000 for one parent. So that's another, at least there is an option, right? So for example, if you have a baby, if you think you want to keep your parents here for 5 years or 10 years, you could opt for that even though you don't meet the balance of family test. So these are the main parent visa categories.
The visa fee is so high and they have a children in Australia, but why the Australian immigration is taking too much lengthy time to grant a permanent residency for parents? Like 12 years is too much, isn't it?
Yeah, it's extremely long time and the department are well aware of it. But because parent visa has capping, which means in a particular year, they cannot give parent visa grants more than certain amount. And with the past freedom of information that we've obtained from the department, it hasn't been more than 5,000 applications per year. Whereas right now, there are 120,000 applications for parent visa waiting. So of that 120, about 60 to 70,000 are the contributory parent visa, which is the 94,000 ones. So people are ready to pay, but because of the capping, they cannot grant more than that capping of the visa. And this is the biggest dilemma, because there are so many immigrants who are wanting to come to Australia, but they are aware of this fact and they are hesitant to come to Australia. That's why Australia are losing highly skilled immigrants, because ultimately everyone wants to unite with their parents. But the fact that the parent visa queue is ever expanding, ever being longer and longer. For example, about 6 months ago, the queue was only 6 years. When we were launching parent visa, it was 6 years. And suddenly, department announced that now any new applications can be up to 12 years. And why is that? Because the contributory parent visa, I feel like since COVID, people have realized the value of being together, realized the value of parents. And for example, a country like Nepal, where there are so many people, so many kids. For example, a family of three, at least two kids are going overseas. You know, in some houses there are three kids all overseas, and ultimately you have to bring your parents here, right? So people have realized the fact since COVID, and I feel like there's a high upsurge of parent visa applications. And because the capping has always been almost fixed, but the applications are going up and up, that's why the queue is going up. So I don't see the queue going down unless department increases the capping for parent visa. But at the same time, it's very highly political, because whether the left wing comes in power, the right wing, it doesn't matter. They don't care about parents, because they think parents as a burden on the taxpayers' money, because they know that they're not going to generate income, and 10 years down the track they might ask for pension, things like that. But it's a very sad, sad story, because we as a taxpayers, it's our parents, and we are ready to pay for their fee. That fee is the ultimately going to be the medical cost, right? Because they are given Medicare 12 years. After 12 years, that whole $94,000 is supposed to cover the cost of Medicare, right? It's not supposed to be a burden on the government, and still they have to wait for 12 years. So it's a very sad situation.
Wow, that's so interesting. So,
Yeah.
have you known any peculiar case where applicants have provided the fraudulent document or misleading information to Department of Immigration, and the case officers have verified by going to workplace visits, and the visa has been cancelled?
I haven't came across personally, but because we have this organization where all the agents and the lawyers, we come together and we share our experience, and I have heard of many of these cases where where there's a raid at the work. Especially it happens with I've heard places like fast food or restaurants and things like that, where people are working unlawfully or they're doing overtime. And yes, if you get caught, there are chances of your visa cancellation as well. So you have to be very careful, and not just with work. I recently read a story where an applicant declared themselves to be a dependent, as in like a child on their parents' parent visa. And ultimately, when it was the applicant's turn to sponsor someone else for a partner visa, he made a mistake and said that when he was a dependent on his mom's visa, he was already in a relationship with his now partner. So things like that, it came around, 7 to 8 years later to bite him, and his own PR got cancelled. So he would have never thought that his PR would get cancelled. He was trying to give PR to his partner, and come around, his own PR got cancelled. So you have to be very careful with, immigration, and you have to make sure you don't breach the visa condition and things like that.
So, what strategies do you use to make sure that the documentation of applicants is accurate and meet the requirements set by Australian immigration?
First of all, we have a document checklist for almost every visa subclass, and we give that out to our client. And when we're trying to formulate that checklist itself, we just don't rely on the Department of Immigration website. Being a migration agent, we have the privilege of getting hold of the migration policy and the laws and the acts, where all the documents are properly listed, and there's reasoning behind why that particular document is needed. So I can figure out, if I don't have this particular document, what's the alternative for it. So because of the policy, I know what documents are needed. If A is not available, I'll go for B. So that's how I make sure that I have all the documents. And when we lodge for a visa, we make sure we always double and triple check. So my team and I, someone else would be, drafting the visa, then someone else will check, and ultimately when I lodge it, I will double check again. So that's how we make sure that all the documents are provided, all the documents we get within time. Another crucial thing is you have to lodge the visa within time. So someone's visa might be expiring in a week's time, someone's might be expiring in a month's time. We have to prioritize that as well.
So then what's the difference between the applicants of high risk country, low risk country, and 190 visa and regional 491 visa?
Is that it all comes down to the financials and the English.
Okay.
So, for example, someone from a low risk country, like for example France, if they're applying for a student visa, the documents they have to provide does not include English. It does not include any financials, so they don't have to provide bank statement. They don't have to provide English certificate like IELTS or PT. When it comes to finance, department is being extremely strict right now, and because of that reason, the universities are being strict. Because previously universities didn't care if someone was onshore, they would give you the COE more easily. But right now, the universities are wanting all the transcript of bank statement. If there's a deposit of $500,000 or $800,000, they want to know in rupees, for example. They want to know where that money came from. So that's the difference between high and low risk country. Let's say, for example, someone from France, they don't need to provide English, or they don't need to provide any financials. Whereas someone from Nepal or India, they need to provide all those things. And not just provide it, when it comes to finances, the department gets very strict. They will check your bank transactions. So just the bank balance itself might not be enough, especially if you're offshore. If you're onshore, the bank balance only might be enough. But if you're from offshore, you need to show the whole bank transaction, and they would want to see more than 6 months of bank transaction. And if there are big amounts being deposited, they want to know where the money is coming. They will want explanation, if possible, evidences. So they really want to know the clear evidence of all the money being saved or any income being generated. So that's for the low risk country. And also the high risk countries, visas, they don't get granted straight away. They have to do medical biometrics, and they have to, usually I've seen the visa usually takes at least minimum 1 week to be granted, whereas the low risk country, their visa gets granted straight away. So if you lodge the visa today, it gets granted today. Talking about the difference between 190 and 491, 190 is the state sponsored visa, where the whole state is sponsoring you, so you don't have to stick to a regional area. Whereas 491 is the regional visa, as in like after you get the visa granted, if you're onshore, if you haven't moved into the regional yet, you need to make a move into the regional within a few months. If you're coming from offshore, you need to move into the regional within 60 days. And regional visa, you need to work and wait in the regional visa for 3 financial years, and provide your tax return of the 3 financial years, showing that you have lived, worked, studied, everything in the regional area. Then only you'll be eligible for the PR visa, which is subclass 191. Whereas 190, you get the PR straight away. Now, with the regional visa, there are a few more things you have to be very careful, because it comes with a visa condition, and that visa condition, what it does is it doesn't allow you to get out of the regional area for too long. So let's say, for example, if you are going to city area now and then for work related or for holiday, that's fine. But if someone's going to city, let's say, for example, 2 days, 2 day in a week, every week kind of thing, then you might breach that visa condition. And if you breach that visa condition when you apply for your PR 191 visa 3 years down the track, the department will check to see how many times you've been going to the city. We don't know how thoroughly they're going to check, but they have said that we will check, right? So when they're checking, they might refuse your 191 visa, but not just refuse that, they might cancel your 491 visa because you have breached the visa condition. So we don't know how strictly the department is going to govern this rule, on all the 491 holders. So, but be careful if you're on a 491 visa. If you're going on a holiday, don't go for a holiday for more than 2 months, because they have also announced that more than 60 days of consecutive leave from the regional area might get you in trouble, might mean that you have breached the visa condition. So you need to be careful about those things as well. With the 491 visa. But other than that, people get scared to go for 491 visa because they think it's not PR straight away. But eventually you will get the PR 100% if you meet all that condition. If you live, work, and study in the regional area, you should be all right. You'll get the PR in 3 years' time. So I always tell people, if your occupation is not a very high demand occupation, if your points are not very high, rather than staying in the city and waiting for the invitation and never being invited, go to regional area. I always tell them that, because there's high chance of you being invited.
So, according to 2023, what are the high demanded occupation till now?
The high demand occupation as per 2023 record, I could say, is nursing for 100% for sure, engineering, social work, a lot of occupation from the health sector, which consists of physiotherapists, all those health professions, even community worker, disability are also high demand, but their visa is not as straightforward. As we all know, the department announced the industry aged care labor agreement, but that labor agreement itself, getting that labor agreement done itself isn't going to be that easy, because you need to have the memorandum of understanding set up, which means the employer needs to have the union involved within their business, 100%, and not all employers are ready to have the unions involved. So that's another, high demand occupation, but with some restrictions. So I would say, if I could name four, I would say nursing, engineering, chef, social work, also booming, especially in Western Australia.
So, how can people connect with you and get the best services at the perfect timing?
Timing is always perfect. You can contact me anytime, but the best method of contacting us is through phone or email us, or we are very active on social media. Our main marketing platform has always been social media, so I get contacted via Facebook, via WhatsApp, Viber, emails all the time. And we do charge for consultations, for especially for family visas, or if there's any refusal or cancellation or any complicated visas, or if you want a good 1 hour of sit down consultation, we do charge for it. But if it's a quick conversation, like 5-10 minutes, you have one or two questions, feel free to email me and I'll be happy to answer your queries.
Shraddha, any suggestion do you want to give to those applicants who are in overseas and planning to migrate to Australia? What's the best timing to contact the migration agent to those applicants?
The best time to contact the migration agent is obviously at the very beginning, because you need to know a few things. Migration is a process, and you need to know how long it's going to take, what are the steps involved, what are the fees, what are the chances of you being invited. So only a migration agent can give you the whole big picture before you jump into applying for or trying for a permanent residency or migrating to Australia. So I would say at the very beginning is the most crucial part, because if you're especially trying to apply for skill migration, you need to first get a skill assessment done. And getting a skill assessment done for doing a skill assessment for a couple of occupation could be easy, but for a couple, for example, managers, it can be very hard. At the same time, you know how I said nurses are of high demand, but doing a skill assessment for a nurse who are overseas, no matter how many years of experience they have, can be very hard, because they need to get their registration from AFRA. They need to sit for the MCQ exam, the multiple choice question exam, which is very, very tough. I've known a couple of nurses who's tried from a couple of different countries and all failed in their first attempt. So that's why they need to manage the expectation, and only an agent can, an agent or a lawyer can manage your expectation, because the first step, if the first step is very hard, very tough, you might be discouraged to enter into this whole migration world completely. You might shut down. and that's not a good idea. So if you know that your first step is going to be hard, you're prepared for it, and then you can move on to your second step and all. So for example, first step would be doing a skill assessment, giving your English examination, and then you fill in your expression of interest, which is the EOI. And a lot of people think, well, once we fill the EOI, we'll get invited. It's not like that. It's not 100% for anyone. But again, an agent will help you manage your expectation. How much are the chances of you getting invited?
Shraddha, you talk about the registered nurses, but what about the doctor? Like they can migrate to Australia and can they get permanent residency through doctor? What's the process?
As I've already told you, for nurses, they need to pass the exam through AFRA. So you can very well imagine this is a highly governed field of work. So if it's hard for nurses, it's going to be even harder for the doctors because they have to pass the examination with the Medical Board of Australia, similar to AFRA. And they can't just come to Australia for PR straight away. They need to find an employer, and they need to work for that employer for, normally it depends on the employer itself. Some employers make you work for 2 years, some 4 years, and then only you can move on to the employer sponsored visa. Their visa processing are very lengthy. They need to be in contact with the employers in Australia, and again, starting from the very start, they need to pass the exam.
So I don't know, like, is it a right question to ask you or not as a registered migration agent? But I want to ask, like, I have personally seen the economic crisis and the financial situation of Australia during the pandemic, and the Australia is dependent on the immigrants, and the rules are changing day by day and like week by week, and the applicants are so much confused, like how to settle in Australia. Like, why is the rule so?
Look,
Why?
the answer is not something that you will like it, because even us migration agent have to battle with the fact that the rules are always changing. We have to always, be on our tippy toes with the new immigration rule, and it's always been like this. It's not because of COVID. It's always been ever changing. And for example, COVID visa, people were using COVID visa, so lightly, and everyone was depending on COVID visa to, prolong their stay here. And suddenly the department announced on I believe last week, that from tomorrow onwards, or sorry, it was day after tomorrow onwards, you can no longer apply for COVID visa, and only those people who already hold COVID visa can apply for COVID visa, but only till January. So rules like this, they change, within overnight. But some rules, they announce it and take 6 months to change it. So it is very, this whole migration field is ever changing. It's unpredictable, it's ever changing, and I feel like it's more political than anything else.
Applicants who wants to lodge their visa by themselves without any consultation. What's your opinion towards those applicants?
It depends on what visa subclass they're lodging. So, for example, if it's for Australian citizens' parents' visa, trust me, the visitor visa is going to be easy. But at the same time, if it's for the same Australian citizens, if they're applying for their brothers and sisters who are young people, then I think it's a good idea to consult an agent or a lawyer, just so that that visitor visa doesn't get refused. Because once it gets refused, trust me, it's going to get refused again very easily. So it purely depends on whose visa you're applying and what visa you're applying. So for example, a lot of the time people apply for partner visa, and majority of the people think that, oh well, I'm in a genuine relationship, I can do it myself, it's only a partner visa, which is true. It is true. It's only a partner visa. But there are certain rules with partner visa. For example, with the partner visa, you cannot sponsor more than two partners in a lifetime. But there is a loophole which will allow you to sponsor a third partner. There's a risk to it, but only an agent can tell you if you can mitigate that risk or not. So if someone goes ahead and applies for the third time, trust me, their visa is going to get refused 100% straight away. They might have to go to AAT and all, but yeah. So with the partner visa, again, coming back to partner visa, yes, you can apply it, but if you don't apply it in a proper way, I've had clients come to me with a complaint saying that I lodged my partner visa myself. It's been 3 years, it's been 5 years. When we lodge the partner visa onshore these days, it usually doesn't take more than 6 months, unless it's a very complicated case, maybe 1 year. So there goes your answer. It depends on how long the visa processing is going to take. It depends on what subclass you're applying for and whom you're applying for. So if you if you can calculate those things, then maybe you can decide whether you want to go and see an agent or not.
I personally have seen like the applicants from high risk country, they are like too much trust on education consultant and migration consultant. They don't want to send the document by themselves. But the applicants of low risk country, they don't want to invest a penny on migration consultant or education consultant. What's the difference? Like, why is this?
As I've told you, the low risk country people can come to Australia very easily as well compared to the high risk countries. So it all comes down to the fact that they are well aware that department is not going to refuse their visa unless there are major issues. Whereas with high risk countries, the department are going to look at their visas with big binoculars and check each and every details. And it's really annoying because we we have a lot of clients who come to us who's applied for example, visitor visa. They have applied previously for their brothers or sisters and it got granted, and they think that, well, that time it got granted, they've been to Australia, surely they're gonna it's gonna be an easy application, and they lodge it again by themselves, or they lodge it with a very few minimum documents and it gets refused. So it all comes down to providing with the migration system. Not all visa subclass has the same amount of document required. For example, if it's a student dependent visa, and if you're applying for a student dependent visa, the department is going to look at your application with a different angle. That is the requirement of that subclass. So they need to meet the GTE criteria if you're a student dependent, right? But if you are a dependent of a 485 visa, both are temporary visas, but just because the subclass is now different, the department does not care about the GTE, which is the genuine temporary entrant criteria. So when someone is overseas, when their partner is overseas, if they try and bring them here on a student dependent visa, it might get refused. But the same person, if you apply when the person in Australia is on 485, they'll be able to bring their partner from overseas easily. So the same two people, but it's a different visa subclass. That's why the hardness of getting it approved or not depends on what visa subclass you choose for.
Well, like the Australian immigration like rules is interesting and like exciting and like frustrating too for those applicants who wants to settle in Australia. It was great talking with you, Shraddha. Thank you so much for your time, and hope I will see the successful visa application rates from you in near future. And I can see now too like lots of visa success rate from you, from your services. Thank you so much for your time, Shraddha.
Thank you, Shrishti. Thank you so much for having me. It was a pleasure, talking to you and doing this interview.